Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the 8 goals of a good estate plan. Now on our website, learn-about-law.com, we have in-depth articles about each of these 8 goals. So if you want to learn more about what each of these goals are and how we accomplish these goals, you can go to our website and check out those articles. But today we're just going to give a broad overview of each of the 8 goals of a good estate plan and tell you the tools that we use to accomplish those goals, to make you a little bit conversant in estate planning and even just identify what you should be thinking about when you're talking about estate planning with your attorney. I divide the 8 goals of a good estate plan into 2 groups. One of the groups consists of 4 general goals that apply to nearly everybody. The other group consists of 4 specialized goals that only apply in special circumstances. So we'll tackle the general goals first, and then we'll go into the specialized goals second. So the first general goal that applies to nearly everybody is the appointment of fiduciaries and the distribution of assets. And this is something that we can accomplish with either a trust or a will. Sometimes, depending on your situation, you'll have both. Sometimes you'll have one or the other, and that's something to talk to your attorney about. But appointing fiduciaries basically comes down to naming a trustee if you have a trust or an executor if you have a will to manage your assets when you pass away and make sure that they get to the right people when you pass away, and also naming a guardian for minor children. So that's something that we accomplish with a will. That's the one thing that a will can do that a trust can't do, is name a guardian of minor children. And that's why sometimes people will have a trust and a will. But with either a trust or a will, you appoint the person that's going to be responsible for following your instructions in the trust or the will and distributing the assets to the right people. Distribution of assets is also part of this goal, and that's making sure that you've listed who's going to get what. So if you have an heirloom or a fancy jewelry collection and you want it to go to a particular person, you want to list that in your trust or your will to make sure the right person gets the right assets, and also laying out how you want everything distributed. And again, for this first goal, appointment of fiduciaries and distribution of assets, that's something that we use either a trust, a revocable living trust, or a will to accomplish. The second goal is avoiding probate when you pass away. Probate is a year-long court case, and we have a lot of articles about probate at learn-about-law.com, so you can learn more there. But it's a year-long court case where basically the court oversees the distribution of your estate. It's bad for a couple reasons. One is that it takes a year before your beneficiaries and your loved ones can get access to your assets. So they're tied up in court for a year when your loved ones need them. The second reason it's bad is it costs 5 to 10% of your estate in attorney's fees. This is something that the court will just award to the attorney that's handling your case. So the bigger your estate is, the more expensive the probate's going to be. The third reason it's bad is it's a major headache for your executor. They have to deal with an attorney, file reports, appear in court for about a year, and that's not something that anybody really wants to do. So the good news is that we can avoid probate using a revocable living trust. The rule in Illinois is that if you own any real estate outside of a trust, or more than $100,000 of non-real estate assets outside of a trust, then generally your estate goes through probate. So we use a revocable living trust, which is a fictional legal entity that can hold property separate from you, even though you have complete control over the property. And we transfer your real estate and your major savings accounts into the trust during your lifetime, so that when you pass away, you've got less than $100,000 outside of the trust and no real estate outside of the trust. And if we do that, then your estate won't have to go through probate. It can be resolved immediately through a small estate affidavit without hiring an attorney. Your loved ones get access to your assets right away, and it's much smoother and it's much less of a headache for your trustee. So that's why people, when they come to me and say I need a will, if their estate would qualify for probate without a trust, usually what they'll have is a revocable living trust. And then if they have minor children and they need to name a guardian, they'll have a will in addition to that trust, like we talked about in the last goal, appointment of fiduciaries. All right, so the third goal is avoiding a guardianship proceeding if you become mentally incompetent. So everything we've talked about so far is what happens when you pass away. This is what happens if, through accident, disease, or old age during your lifetime, you become mentally incompetent. And if you have powers of attorney, financial power of attorney and a healthcare power of attorney in place while you're still mentally competent, when you become mentally incompetent, you won't have to go through a guardianship proceeding because you'll have named your financial guardian and your guardian of your person in the financial healthcare power of attorney the financial power of attorney and the healthcare power of attorney, respectively. If you don't have powers of attorney in place and you become mentally incompetent, then in order for even your spouse to sell your home or file your taxes or access your accounts that are in your personal name to pay your bills, or decide where you're going to live, check you into assisted living facility if necessary, they would need to go through a court proceeding to be named your guardian. And we want to avoid this for the same reasons we want to avoid probate. It takes about 6 months, so for 6 months when your spouse's life is in upheaval already, they're not able to access your assets or make major decisions on your behalf because it takes 6 months to be named your guardian. It can be done on an emergency basis, but that's more expensive. And that leads us into the second reason it's bad. It's because it costs a bunch in attorney's fees. It can cost $5,000 to $10,000 in attorney's fees, where a power of attorney costs about $100. So you're saving a lot of money by doing the planning early. And the third reason it's bad is, just like probate, it's a major headache for whoever's trying to be named your guardian. There can be disputes over who your guardian is going to be, and you've got to line up expert witnesses to testify as to your mental incompetence and appear in court. And then for the rest of your life, if you have to have a guardian named through a guardianship proceeding, your guardian has to go into court every year, spend more money every year, and file a report as to how they've managed your assets over the course of that year. So that's a major hassle, costs a lot of money over the course of your lifetime, can be easily avoided with powers of attorney. The fourth goal of a good estate plan is making sure that you've made your end-of-life decisions clear. This is something that not everybody has to do, but some people don't want their loved ones to have to terminate life support on them if they're in an irreversible coma. So what they do is they have something called a living will. And if a living will is in your medical file, the doctor is ordered to terminate life support if you're in a vegetative state, and the doctor thinks the only purpose for continued life support is to keep you permanently in that vegetative state. So basically you're in an irreversible coma and the doctor thinks there's zero chance of you coming out of it. If you have a living will, the doctor is ordered to terminate life support, and the legal decision is taken out of the hands of your healthcare agent that you've named in your healthcare power of attorney. People do this for a couple reasons. One is that they don't want the emotional burden of making that decision to be on their kids or their spouse or other loved ones. Two is that they just don't want to be left in that state for an extended period of time. Either because they don't physically want to be left in an irreversible coma, or they don't want to drain the finances. So they have a living will that takes that decision out of their family members' hands. An alternative to a living will is in a healthcare power of attorney. There's a multiple choice section where you can state what your wishes are in that situation, but it's not legally binding on your healthcare agent. So your healthcare agent has some of the emotional burden relieved because you've stated what your wishes are, but they still have the ultimate legal decision. So those are the four general goals of a good estate plan: appointment of fiduciaries and distribution of assets, avoidance of probate, avoidance of guardianship if you're mentally incompetent, and stating your end-of-life wishes. Those apply to nearly everybody. There's four specialized goals that apply only in special circumstances. The first of those is estate tax avoidance. The estate tax exemption is $4 million in Illinois as of the time of this recording, and something like $5.56 million federally. And if you have more than that $4 million, then your estate is going to be subject to estate tax, and you want to account for life insurance death benefit as part of your asset calculation. So if you have a $2 million life insurance policy, that's included in your assets for the purpose of estate tax. And there's some really easy things we can do to either raise your estate tax exemption or take things out of your taxable estate in order to make it so that you don't have to pay estate tax, or that you're paying the minimum under the law that you have to pay. One of those is called an A-B trust strategy, where instead of having a joint trust for one couple for the purpose of avoiding probate, we have one trust for each individual in a married couple, and that allows that allows them to take advantage of each other's estate tax exemption, effectively raising it from $4 million to $8 million in Illinois. And if you still have a problem with estate tax, then we do something called an irrevocable life insurance trust, or an ILIT, which basically takes your life insurance policies out of your estate. And then if there's still an estate tax issue, we do something called GRITs, GRATs, and GROOTs, which are grant-to-retained interest trusts, grant-to-retained annuity trusts, and grant-to-retained unit trusts. And this gets really complicated, and I don't want to go into details. There's an article about estate tax on our website. But basically, these trusts allow assets to be removed from your estate and appreciate over time without the appreciated value being part of your estate for part of estate tax. This is getting a little arcane, so I don't want to focus on it. But if you're approaching $4 million, the bottom line is you should be talking to an attorney about estate tax avoidance, and we can help make sure that all of your assets go to your family members and not to the government. The second specialized goal of a good estate plan is special needs planning. So if you have special needs and you're receiving benefits from the government, there's usually a limitation about how much wealth you can accrue before your benefits start to be reduced, or how much income you can have before your benefits start to be reduced. And if you receive an inheritance from your parents, that can basically blow up your benefits that you're receiving from the government. And you can't really get a job that pays any amount of money because if you receive an income over and above the specified monthly amount, then your benefits are going to be reduced. We can resolve that with special needs trusts, also called supplemental needs trusts, or ABLE Act accounts. That's a separate vehicle. And those are basically tools that allow us to allow you to have an income and acquire wealth and put it either into this ABLE Act account or your supplemental needs trust rather than an account in your individual name. And if we do that, then it doesn't count as income or wealth for you as you acquire it, and it allows you to retain your Social Security benefits that you're receiving from the government while also receiving gifts, inheritances, owning property, and earning an income. And like with all of these specialized goals, they're pretty complex, pretty arcane. It's something that you should talk to an attorney about. The purpose of this video is just to make sure you understand that there is something you can do about them, and that's something you should think about in your estate plan. And if you are a parent of a special needs person, you need to incorporate their special needs trust into your own estate plan so that when you give them an inheritance, it doesn't go to them as individuals, it goes into their trust, and they can get the inheritance without ruining their Social Security benefits. So that's enough said on that. If you need more information, we have articles on this at learn-about-law.com as well. The third specialized goal is Medicaid planning. So when you go into an assisted living facility, you're just like with a special needs trust, you're required to spend down your assets and have a limit to how much you can have in assets and how much you can have in income. But we can use trusts and life estates to take real estate or other assets out of your estate for the purpose of Medicaid and allow that to transfer to the next generation while you can still be eligible for Medicaid and receive long-term care. The fourth and final specialized estate planning goals is protecting assets from creditors. So if you're in a profession like a doctor where you've got a high chance of liability, or there's some other reason that you think in the future creditors might be coming after you and you want to protect your personal assets from creditors and retain your family's wealth, there's certain tools we can use to do that. You've got to give up some control over the assets, but we do that with irrevocable trusts, family LLCs, and family limited partnerships, and just generally through incorporations and insurance. So that's like all of these specialized estate planning goals. This is where you're going to get more in the weeds, and they're really going to be dependent on what you're willing to give up to accomplish your goal, and what your personal situation is. So this is something that you would want to talk in depth to an attorney about. And again, there's more articles about this on our website too. So again, there's 8 goals of a good estate plan. And we've got them all laid out on our website. 4 of them apply to nearly everybody, 4 are a little bit more specialized. If you have any questions, you can schedule an initial consultation at 630-324-6666, or you can go to learn-about-law.com to read articles about each of these goals, and really everything we talked about we cover in depth on our website. If you're a business owner and you'd like to check out our business podcast, go to seizeyourbusiness.com, where we interview business owners about strategies that you can incorporate into your business model. So, thanks so much for listening.